All right, good morning, everybody. It's not Firearms Friday yet, but I still got a gun story that we need to cover, and I don't think it can wait. So y'all buckle up. I hope you got a cup of coffee and ready to rock and roll. Good morning. Good morning, everybody. So we got a story here about a man named Dexter Taylor out of New York who was just convicted on some gun crimes. And I'm gonna read more of this article than I usually read in the course of this analysis, but I'm gonna read this excerpt without showing you the article, because there's a point to be made here. The jury found Taylor guilty of second-degree criminal possession of a loaded weapon, 4 counts of third-degree criminal possession of a weapon, 5 counts of criminal possession of a firearm, second-degree criminal possession of 5 or more firearms, unlawful possession of pistol ammunition, violation of certificate of registration, prohibition on unfinished frames or receivers, and 2 lesser charges, including third-degree criminal possession of 3 or more firearms and third-degree possession of a weapon. Okay. None of these things are crimes. Now, this happened in New York City. You got possession of a loaded weapon, possession of a weapon, possession of a firearm, possession of 5 or more firearms, possession of pistol ammunition, violation of certificate of registration, and a prohibition on unfinished frames or receivers, and a third-degree criminal possession of 3 or more firearms, and a third-degree possession of a weapon. Guys, shall not be infringed. The Second Amendment, unlike law generally, could hardly be more clear. Shall not be infringed. Okay? The word infringed is one that we don't use often in any context outside of conversations about the law, Second Amendment gun law. But it is a word which literally means to attach or surround something with. The fringe on a jacket, for example, right? You got a Western style jacket with tassels, and you got a fringe. That is attached to or surrounding the garment. The language shall not be infringed, right? Many people hear that language and they think that the word infringed means that the right shall not be compromised or violated, or that you shall not be prevented from exercising the right. This is very simple, but it is a legal term of art. What the language of the Second Amendment means, shall not be infringed, is that no law whatsoever shall even refer to your ability to keep and bear arms. That means that all restrictions on the keeping and bearing of arms, which is to say muzzle length limits or definitions, magazine capacity limits, registrations, background checks, tax stamps. There is no law in the United States which refers in any way to guns which is constitutionally tolerable. I make that statement unabashedly and without reservation. No gun law is constitutionally tolerable, shall not be infringed. You will not place things near it. You cannot reference firearms or any weapons in the construct of law. And I know somebody out there may say, but what if somebody murders somebody with a gun? Okay, fair enough. Or a knife, or a bomb, or a can of gas, or your bare fucking hands. Murder is a specific act. And the outcome of that act can be achieved with the application of any number of dangerous implements. What implement was used in the act is irrelevant to the act itself, completely and entirely. The outcome that a person was unjustly unalived is completely divorced from the mechanism which caused that outcome. A person who is strangled to death with giant hands is not somehow magically less murdered than a person who is shot to death with a firearm. They are precisely as dead. You know, because I mean, obviously, dead is an absolute state. It doesn't have gradations, right? If that were the case, we would be tying the shoelaces on our dead to avoid zombies. So they trip when they crawl out of the grave. They're easier to get away from. This story caught my attention specifically because of what the judge in this case said. So I'm going to fast forward in the article a little bit, and I'm going to show you where the specific quote is actually printed. The judge said, oh, I blew right by it. Parade of Horror. No, that's not it. There it is. The judge said, do not bring the Second Amendment into this courtroom. It doesn't exist here. So you can't argue Second Amendment. This is New York. Holy shit. This guy was charged with 13 weapons charges. And remember, I didn't show you the article earlier when I was reading over the list of charges, because you would have seen this headline. This article comes from redstate.com. It's published day before yesterday. New York City man convicted over gunsmithing hobby after judge says Second Amendment doesn't exist in this courtroom. Gunsmithing hobby. So this guy lives in New York City. He's a software engineer, I think. Yeah. And basically, it looks like he set himself up a little gunsmithing shop at his house and got into the hobby of building guns. And for that, he was charged with 13 counts possession of a loaded weapon, third-degree criminal possession of a weapon, et cetera, et cetera. We already read through that. So Taylor, a 52-year-old New York native and a software engineer, discovered the world of gunsmithing years ago. He decided to take it up as a hobby and possibly turned it into a business later. However, when a joint ATF-NYPD task force discovered he was legally buying parts from various companies, they opened up an investigation that led to a SWAT raid and arrest. There's no allegation here that the man committed any crime prior to the SWAT team raiding his apartment. Right? So, just for the sake of argument, let's take it at face value that the charges he's charged with are crimes in New York City. I know. That's a psychotic statement. The fact that New York City, bear this in mind, states like New York, California, that have massively restrictive gun laws that are what they call sanctuary states, right? That encourage people who live in states with strict abortion laws or states that don't perform child mutilation procedures. They encourage those people to flee to their states so that they can go there to break the law. These states are rogue actors. These states are essentially insurrectionist states. They are engaged in the open defiance of the law, which is the Constitution. Right? And what they're doing is they are essentially nullifying the federal government. Now, in a sense, I can kind of get behind that. It would not break my heart to dissolve the federal government and just do away with it. I'd be pretty comfortable with that. And a lot of states would have to make a lot of important changes, and it would be interesting for sure. But what New York and California and states like them are doing is they're acting in open defiance and violation of the law. Because there are in fact powers that the federal government has to which each of these states undersigned in ratifying the Constitution or ratifying their own statehood thereafter. The states agreed to abide by the laws set forth in the Constitution, one of which is, you can take my gun from my cold, dead hands. And good luck. If it ever comes to that, you send me as many armed men as you're willing to lose. So, the fact here, according to the story, according to the court filing, is that based on the information, right, the joint ATF NYPD task force determined that this guy was ordering firearms parts online, committing no crime, right? If we accept for a moment that all of these things are reasonable, with the exception of the prohibition on unfinished frames or receivers, which is also insane, right? Because bear in mind, the ATF has tried this many, many times, and they've been shot down. They're not allowed to classify all of the individual divorced parts of a firearm individually as firearms themselves. Because let's say you've got a 1911, and you and so what you have is a gun. If the ATF is allowed to regulate the individual parts as firearms themselves individually, which they have tried to do on many occasions, then what happens is, if you have a gun, if you have a 1911, you have a gun, and you disassemble it to clean it, and you take the upper receiver away from the lower receiver, now you have two guns. And you set the lower receiver down, and you remove the bolt carrier and the barrel. Now you have four guns. And then you take the bolt carrier down into its individual parts, and now you're up to like 8, 9 guns. Firearms. Right? That's what. So if you put them all back together and guns are illegal, you've only got one count of crime. But if you're caught while you're cleaning it and it's disassembled, then you have that many counts of possession of a firearm. It's fucking psychotic. And that's why the ATF has been disallowed from classifying the individual parts of a firearm as firearms themselves. So Taylor, a 52-year-old New York native, a software engineer, discovered the world of gunsmithing years ago. He decided to take it up as a hobby and possibly turn it into a business. However, when a joint ATF NYPD task force discovered he was legally buying parts from various companies, they opened up an investigation that led to a SWAT raid and arrest. So they didn't have anything to charge him with, according to this, until after the raid. Which leads me to suspect that when this gets appealed, and oh my God, will it, the question is going to have to be asked. Was the raid and arrest even a lawful action to begin with? Right? Like you might have a kilo of cocaine hidden in your box of Captain Crunch on top of the refrigerator. But without due process of law, a warrant signed by a judge on the presentation of reasonable articulable suspicion and probable cause of a crime, then there is not a lawful mechanism through which the government can access the information that you have a key of coke hidden in your Captain Crunch box. They have to have some information in order to compel that search, unless you just give it up, unless you just consent. Right? So yeah, come on in and search the house. So this by itself is dubious. This guy is currently being jailed on Rikers Island as he awaits sentencing. Taylor's conviction highlights the ongoing battle for gun rights. During an interview with Vinu Varghese, Taylor's defense lawyer, he detailed how Taylor's trial proceeded and highlighted a distinct bias in favor of the prosecution. Excuse me. Varghese described how Taylor became fascinated by weapons science during the COVID-19 lockdowns, which inspired him to take up his gunsmithing hobby. He ended up building, I believe it was 8 pistols and 5 rifles or 6 rifles, AR-style rifles, and then 8 or 9 Glock pistols that he built, Varghese said. In an interview prior to his conviction, Taylor told Red State, "I found out that you can actually legally buy a receiver and you can machine that receiver to completion, and you can buy your parts and you put them together and you've got a pistol or a rifle. And once I saw that, I was hooked. I was like, this is the coolest thing ever. This is the most cool thing you could possibly do in your machine shop." From the beginning of Taylor's trial, it was evident that the court would be biased against the defendant, according to Varghese, who explained that 2 judges presided over his case before the current official, Judge Abina Darke, took over. And Judge Abina Darke. The judge disrupted Varghese's opening statement multiple times as he tried to set the stage for Taylor's defense. Even further, she admonished the defense to refrain from mentioning the Second Amendment during the trial. Varghese told Red State, "She told us, Do not bring the Second Amendment into this courtroom. It doesn't exist here. You can't argue Second Amendment. This is New York. Guys, this is not complicated right here. Darky has no business on the bench. That statement, you cannot argue the Second Amendment. The Second Amendment doesn't exist here. This is New York. You cannot argue the Second Amendment? No, fuck you. I have a First Amendment right that says I can say whatever I want. I can petition my government for redress of grievances. I can absolutely argue the Second Amendment. So the judge right here on the bench in her official capacity, wearing the robes, by making that statement alone, has personally committed at least 2 counts of the violation of civil liberties under color of law. As a judge, as an official, a government official, she has asserted that she has the authority to revoke your First and Second Amendment rights at her leisure. She should be executed for this crime. Section 242 is very clear. It is punishable with fines, incarceration, and up to the death penalty if the violation of rights is severe enough to justify it. And I argue this, that the violation of the Second Amendment is always one which endangers the lives of those whose rights are violated. Because it is always the case that when you strip someone of their Second Amendment rights, you are actively increasing their risk of death, measurably and substantially. And I would go so far as to argue that it is more substantial in a high-crime city like New York. So substantial, in fact, as to rise to the bar to meet the needs of execution under Title 18, Section 242. Not a difficult argument to make. Perhaps a difficult argument to move through courts, but at a minimum, I do not believe a reasonable person could look at this case and conclude that this judge should continue to be a judge. She should be impeached and disbarred immediately. Darky is an active opponent of the Constitution and, by extension, the entire United States. That's not complicated. That's plain. Varkey said he had filed the appropriate paperwork to preserve these arguments for appeal, but that the judge rejected these arguments and she went out of her way to limit me. During the trial, the prosecution attempted to paint Taylor as a dangerous individual who was building dangerous firearms in his basement. In this vein, the prosecution objected to allowing Taylor's family in the courtroom to show support, nor did they allow his upstairs neighbor, who knew about Taylor's hobby, to testify on his behalf. Varkey described the prosecutor's opening statement. He opens up and he says that Mr. Taylor had a parade of horror. He was building this horrible place. When they saw this horror that he was making under the noses of his neighbors because all of those guns intended to hit their targets, basically implying that he was going to do some harm with these things. Now that right there, remember, we just saw that Varkey said that the judge would not allow the neighbors to testify on Taylor's behalf. And that is precisely because the prosecution is making the argument in order to suggest that somehow Varkey was hiding this from his neighbors. The neighbors didn't know about it, and the neighbors are horrified to learn about it. And clearly that's not true. if his neighbors were prepared to testify on his behalf, then A, they were not horrified, and B, they were probably aware and probably pretty comfortable with it. Right? When Varghese countered this narrative during his opening statement, the judge interrupted him again. So Varghese argued, there's no crime here. There's no allegation of violence. I got up and said, you're going to learn what Dexter is, who he is, and you're going to learn, this is interesting, that he never fired these guns. He never fired these guns. The judge interrupted again and asked the lawyers to come to her chambers for the second time. Varghese explained that he believed the only chance of having the case go in his client's favor was through jury nullification, which occurs when members of a jury believe a defendant violated a law, but decided against prosecuting them because they disagree with the law itself or other reasons. Judge Darkey attempted to shut this argument down and led the jury to believe they would face consequences if they did not vote to convict Taylor. That's illegal. That is itself a crime. Okay? So, jury nullification. Jury nullification is used as a mechanism for the people to demand a redress of grievances from the government. Jury nullification is used to shut down unjust laws. Now, it can be used in nefarious ways. It can be used, it's absolutely possible that a dangerous criminal could extort a jury into nullification in order to get away with a crime that he was obviously guilty of. Yes, that is a risk. But, no pain, no gain. There's no reward without risk. Under the law, while it is clearly the case that a judge does not have a compelling incentive to encourage jury nullification itself falls under free speech. So a judge cannot instruct against or disincentivize jury nullification. That is illegal. That is a crime. And in part, it is another violation of Section 242, because you have the right to free speech. The Congress shall make no law. And the judge is here deciding to strip you of that free speech unilaterally. Jury nullification is not illegal. So essentially, the judge instructed these people to vote guilty, instructed the jury to convict, and then suggested that they would face consequences if they did not convict. This reminds me of the McMichaels case and of the Trump cases that are ongoing right now. In the McMichaels cases, we've talked about this several times before because it was such a tragic and just blatant miscarriage of justice. Forget about all the BLM terrorism that was involved. What happened in the courtroom, the judge allowed the defense, in the McMichaels case, the judge allowed the defense to present their defense. And the defense was this: in the course of conducting a lawful citizen's arrest, the arrestee assaulted the arrestors. The arrestee, Arbery, grabbed and attempted to wrestle away the shotgun held by the younger McMichael. In the struggle for the firearm was discharged. And as a result, Arbery met his end. The argument that the defense made was they stipulated to Travis McMichael's holding the gun. They stipulated to his being in control of the weapon at the time that it discharged, and argued that while it is the case that Travis is responsible for Arbery's death, this occurred in the course of a lawful citizen's arrest when the arrestee assaulted and attempted to steal the firearm, and is therefore a reasonable self-defense, a justifiable homicide. The defense presents this defense, and then the judge instructed the jury, for the purposes of this case, we are ignoring the Georgia law on citizen's arrest, and we are going to act like that law does not exist. The judge instructed the jury, after Travis stipulated to being responsible for Arbery's death, the judge instructed the jury to disregard the explanation of circumstances which led to that stipulation. The result is the same as if you were to agree to a plea deal with the DA, say, okay, I'll plead guilty in exchange for these considerations. And then the judge decides, you know what? No. I don't accept the considerations that were offered to you by the DA. Guess what? If the judge decides that the DA's recommendation is not what he wants to go with, you still pled guilty. Fuck you, it's a trap. Right? This is legislation from the bench. These are activist criminals in black robes who are doing the work of legislature from the office of the judiciary. It is horrifying. It is essentially a tacit admission that the entire system of justice in this country has atrophied, has essentially been abolished by its own corruption. Waller asks, wasn't that because it was a federal trial, so the Georgia laws didn't apply? No, actually. To be clear, Waller, that all happened in the Georgia trial, and then after they were convicted in Georgia, the federal government came in and attached additional qualifiers to upgrade the crime from a crime to a hate crime. So they were convicted twice. They were convicted of murder, and then they were convicted of aggravated hate crime murder. Yeah, the state of Georgia found them guilty, and then the federal government found them guiltier. It was an absolute fucking witch trial. It was, the McMichael's case was the entire apparatus of state and federal government going out of their way to telegraph their capitulation to Black Lives Matter's terrorism. It was a letter to the editor that said, we will give you anything you want, whenever, for any reason, and it doesn't matter. So that's what happened with those guys. And this, I mean, I'm just floored to hear a judge say these words. Do not bring the Second Amendment into this courtroom. It doesn't exist here, so you can't argue Second Amendment. This is New York. Yeah, fuck you. I mean, Title 19, Section 242. Hang this bitch. Because what she has done here is violated a man's civil liberties to such an extent as to as to cause him to be in greater risk of death. All right. I'm going to go ahead and put the button in it there, guys. I got to get on the road. So thanks for watching this morning. We love you, and we will see you tomorrow.